established companies, but again, I do have certain experience also working even at very, very early stages. So here, no, it does work. Yes. So the topics that I will cover would be establishing a company, what you need to do that, because I think that's like the first step. So I figured that that's something you might be interested in. Second, about founder agreement, shareholder agreement, and equity compensation or stock options. But again, if you have any other questions, feel free to interrupt. I'm here for your benefit, not to put on a very dry and presentation that I think is important, but really what matters is what you want to know and would like to understand a bit more. So let's talk about establishing a company. There is a conception that this is a lot of red tape, that state institutions are really evil, trying to do everything to stop you from doing your business, but that actually is not completely true. Well, I personally think that it's really not true, especially in Latvia with our level of digitalization, acceptance of electronic documents, especially comparing to other older, more established states. We actually have fairly decent and kind of open regime for anything. So when I'm saying company, I mean Latvian, SIA, sabiedrība ar ierobežotu atbildību. There are other types of companies, but this is the type of company that you will most likely choose. So in order to establish a company, you need certain documents. I will actually show you where you can get some basic templates of them later on. They can be very complicated, but they can be also very, very, very simple. Everything about companies, or most of the things, are governed by commercial law, Komerclikums. You can find it online. And what is the beauty of this law? And I think it's a fairly well-written law, well, based on German law, obviously, because most of our legal system is based on German law, is that it covers the main points when it comes to companies, but it gives freedom for you to deviate from several of these regulations and do whatever you want, structure a company the way you like it. So in order to establish a company, in my opinion, the most important document is the Articles of Association, in Latvian statute. This is the rule book that governs how your company will work. If you are a sole founder, you are just one person that makes a company and then does the business, this is not that important because you don't have other founders, you don't have other shareholders, but this is the most important document, and this is where you write how many shares you will have, what will be the par value of shares, what will be the rights associated with shares, how many members of the board you will have on the company, will there be a council, many those things. Later on, when I'm talking about founders agreement and shareholder agreement and try to build some kind of structure, I will actually emphasize that many of those things that you will see in typical founders agreements, and you perhaps have seen them already based on US-based templates, in Latvia you would actually have to put in the Articles of Association. Why? Because Articles of Association are recognized as a kind of company rulebook, and when it comes to disputes or any issues among shareholders, this is what the court, well, in the most extreme case, or the company register will actually look at. And if the Articles of Association will say that one founder has shares with 5 voting rights and another one with 1 voting right, they will accept this as a kind of company internal rulebook. So this is very important. If you have very limited amount of time to kind of devote to establishing a company suggest you actually focus most of your attention specifically to this document. Another document is the shareholder register. It is very similar to what you might have heard or probably know as cap table, capitalization table. This is a document essentially listing all the shareholders of the company. It's a list, it's registered with the company register, it's publicly available, so it serves kind of as an official proof that you actually own the shares. In Latvia, when compared to, say, for example, United States, for private companies where in US, you can't really know who owns how many shares unless the company tells you. In Latvia, it's a bit different, and I will actually show it to you. You can go to the company registry website and see who's the shareholder of any limited liability company of Latvia. Very simple, but very important. Against something wrong. Yes, please. Okay, so it works now. Another issue is that you need to have a physical legal address. It used to be so that you had to, when you file documents to the company register, also file a consent form from the owner of the real estate, but nowadays it's not necessary anymore. You can agree with somebody who owns a property. Hey, can I register a company at your address? Sure, you can, and then you can use this address. Why is it important? It is important because all the correspondence sent to the company's legal address is considered as received by the company. Court notices, communications from the state, anything, if sent to the legal address, it is legally presumed that you have received it. Similar thing goes with the so-called e-address, e-address, which is now mandatory for all companies, though nobody really looks after that and at this point really do not enforce it. However, state institutions nowadays actually use this for official communication. So don't forget about that. If you have Latvian ID code, persons codes, you can actually register your profile as e-address and receive all the notifications from state institutions. Another thing to consider is you will need to have certain start capital to establish a company. The minimum amount is 2,800 euros. Actually, it can be €1, but that comes with certain conditions when you can do it. If you building up your first company, you have no other companies, you can actually establish a company with €1 share capital. But going in the future, you will have to actually reach that share capital of 2,800. So nowadays, I don't think that's a very, very substantial sum. Why is it important? And it's not that you have to pay this money to state and you don't get it back. No, you just have to put it on company's account. And I will later speak about challenges you will likely face when you establish your company. But this is the money that must be reserved for the company for its operations. Technically, it's the amount of money that you as a founder risk with when you establish a company. And why you would like to or need to establish a company is to split the liability. You don't want to create a startup, say operate as a self-employed person and risk your whole property if the startup fails. You want to make a separate company who's a separate legal person, a separate kind of a person actually, though a legal one, though being a legal fiction, that actually has all the relations with every counterparties and everything. And if it fails, and you get to keep your house and to keep making other startups, other ideas building up. So company is important to kind of protect your self your own property, your family property, from the amount from liabilities of the company, so that you risk only with those amounts that you actually have put into the company. Another important aspect is the founder agreement. In Latvian, it's called dibināšanas līgums, though it can be in other different forms. I will speak about it separately, but essentially it is an agreement among the founders to establish a company. Again, it can be very simple and it can be very complicated. And finally, you need to fill an application form and file it with the company register. So from legal perspective, how it works is that company is considered as established once it is registered in the company register. So let me show you where you can actually find some templates and find some help once you decide to establish a company, and it's actually help you. So any questions so far? Dalībnieku reģistrs. Dalībnieku reģistrs, dalībnieku reģistra nodalījums. So let's share the screen and let me show you how it works. Dalībnieku, yes.
Free form, or is there a binding template?
There is no binding template. The law says what things have to be written there. For example, when it comes to articles of association, there are basically 3 things that have to be there. Name of the company, how many board members are there, and lastly, I think it was, well, let's check it, board, name of the company, and usually, yes, board, name of the company, and the share capital of the company. That's it. You only need these 3 things. There can be many more things, but this is the bare minimum. So actually, let's go to the templates. There is a very good website. It's the website of the company register of Latvia. And well, I will show it in Latvian because I think the English version is limited, especially when it comes to templates, but there's also an English version. Well, actually, let's try the English word. So I would like to found a company, limited liability company, and here you can actually have quite comprehensive information on what is needed. Minimum equity, founders, natural legal persons, etc., etc., etc. So again, the English language version is limited, so let's switch to Latvian and let's find this part. So, and what is in English here? Actually the same, yeah. So here is the list of all the documents that you will need. Application form, you actually have a hyperlink to the form itself. It's a horrendous Word file that you will have to fill. Also in English, actually. Wow, there's been some considerable progress with the company register. We used to translate them on our own. Let's quickly check it. So what we have here. So, oh no, it's not actually, or is it? It is in English, yes. So you just have to fill this form. It looks complicated, but once you start working it actually ain't that bad. The worst part is formatting it because, trust me, it can take a while, but it's not a big deal to fill it. And also here you have templates of the documents usually here. Decision establishment, well, this is establishing a decision establishing or establishing a treaty. This is probably automated translation. This is the founders agreement. And actually, when you click it, you have a template of it in Latvian, I think. So, okay. Yes, here you have the template. Let's check already filled sample, obviously as a file. So you have to download it, and it's all slow and not really interesting, but just to give you an idea, here it is. So, and this lists the bare minimum. Name of the company, share capital, how much of the share capital will be paid by each founder, how much shares each founder will receive, who will be on the board of the company, how the expenses of founding will be covered. This part is actually not really, you can write any amount there, and that's it. This is all you need. You can use this template for basically for your basic needs, and it will work just fine. And the same goes with all the other documents. So you can use this freely. It's considered as an official template, but this is on the company register website, so you can actually use them once you want to establish a company. A piece of advice, keep it simple. When you establish a company, don't try to make it overly complicated. If you have another partner with you, a co-founder, why you need what you need is to kind of agree and look where you might have any disputes, what might be the differences among you, and try to foresee them in the founders agreement, which we will talk about a bit later, but don't try to be overly complicated. You will go with this company to an angel investor, to a seed investor, and they hear those pitches. They hear quite a lot of pitches. And when you come to such an investor and you have a company with really complicated articles of association, really complicated corporate documents, they will actually have to read them, and they don't want to. So keeping it very simple, sticking it to the basic templates is all good and fine at early stages. So don't try to make it overly more complex than it is actually necessary. You can get by just by having these basic forms, and you will get and your relations with your founders, with your other co-founders, with your board, they will be governed by the law. And what the law says is actually usually very, very kind of, well, fair and divides all the rights and everything between founders in a fairly good way. For example, if you have a share split with your co-founder, say 80-20, the law says that if new equity is issued by the company, if there are no provisions in the articles of association how this equity will be split among founders, the law says that any new share capital is split based on the existing proportion. So you won't get diluted by your 80% co-founder having 20%. They will have a majority deciding on issue of new equity. And if it will be done by the company, you will still have the opportunity to keep your existing percentage. So there are no huge pitfalls if you register a company using these basic templates. Your main interests, like ability to subscribe to new shares of the company, are protected. What you might not have is if you have a situation where you are a minority shareholder, you might not be able to appoint board members to your liking. The majority shareholder will actually have rights to decide on that. So for example, if you have a situation where your partner owns 80%, you own 20%, you are completely fine with them being in the majority and deciding almost all fundamental questions in the company, but you want to have a say in appointing a board member, then you will need to write in the Articles of Association that in the shareholders meeting, if a decision is made regarding appointment of the board, the required majority is not a simple majority, but say 90% majority. Then you have to shift away from the default provisions of the law. And this is completely fine. This can be done. We will also later talk about shareholders agreement, but the message here is simple. Keep it simple and rest assured that when it comes to very fundamental question, the law kind of keeps the balance among the shareholders. If you have a 50-50 split, then actually your main concern is that you can be in a deadlock situation. Neither you can't agree with your partner who will be on the board or on fundamental issues, and then you will be in a situation where you can't make any meaningful decision in a shareholder meeting. This is actually the only situation where the law does not say anything. It just says the majority decides. If nobody has majority, you can't really adopt any decision. And this is where actually shareholders agreement could come handy. So let's get back to my presentation, if you could please. And yes, okay, it's here. Right, so don't be afraid of the red tape, use those templates, and it will be in most cases completely fine and dandy. Some things to consider that are not written in the law, but comes from hard lessons of the practice. Your first advisor that you need to hire or get is an accountant, actually. Every company needs to have books in a certain way, needs to file annual accounts, so you will need an accountant. You can establish a company without a lawyer, unfortunately for me, but you will definitely need an accountant or do it yourself because state wants taxes and death and taxes are inevitable, as you know. Bank account. Sometimes opening a bank account is a real pain in southern side of your body. Why? Because banks nowadays are really bent on doing AML and KYC checks. If you are a Latvian resident, most of the time it will be fairly quick and painless, but for foreign residents, it can take time. And I have heard that banks nowadays actually are starting to charge upfront payments for KYC AML checks, which are non-refundable. So this can be a bit of a hassle. So before going to the company register, you will actually need to open a bank account on behalf of the company that will soon exist to pay the share capital. So kind of start working with the bank, go to the bank of your choosing, ask them, hey guys, what will you need to open an account for this? How long it will take, and then what I need to do for you to open a bank account. Nowhere in the law it says that you actually need to use a Latvian bank. You can use a foreign bank. I have not seen or personally kind of established a company that uses, for example, Revolut as their bank account, but technically it may be possible. I think Revolut is a registered bank in Lithuania, so you are not limited to Latvian banks. You need a bank that is able to give you a piece of paper that you will need to show to the company register, which says that this and this person paid up at least, well, this amount on the account of the soon-to-be established new company. Another thing, again, and I will stress this throughout everything what I'm saying, articles of association are important. They are more important than say, founders agreement well, more important than shareholders agreement. So many things that you might have seen written in those founders or shareholders agreement that are usually based on US templates, you actually would like them to be in the shareholders agreement. Explaining why is that so is a bit of a legalish gibberish, but to put it very simply, as I said, articles of association are kept with the company register. They are the official rule book. The courts will see them as an official rule book. And if, for example, the articles of association say that to adopt a shareholder decision, you need a 70% majority, but there is a decision which, say, has only 65% majority, and the question comes before the court whether or not such decision is valid or not. The court will look at the articles of association and say, yes, the articles of association require this majority. This decision is not valid because it's below the required majority. In contrast, if you have a shareholders agreement saying that this and this majority is required, the court will look at the same situation and say, okay, one person has violated the shareholders agreement, but the decision still stands. And the person that has violated the shareholders agreement can go with the claim of damages against the other shareholder. I think you understand the difference. So in one case, that decision is null and void. And in other case, you have theoretical or practical rights to go to a different court to claim damages. And you still will need to prove that you actually suffered those damages. So there is a fundamental difference. And that's why articles of association are important. Categories of shares. Last part of my presentation will be about share options, but in general, you may want to have different kinds of shares in the company. It used to be so that all shares in limited liability companies were created equal. It's not the case anymore. Our government wisely changed this, I think, 5 years ago, one of the best decisions that they have made. And nowadays you can have different categories of shares. For example, you would probably want to compensate your best employees with equity, but you may not want to give them voting rights. You are happy to share profits with them, happy them to participate in company's growth, and even if you go for an IPO to become filthy rich, but you may not want them to be able to vote on the shareholders meeting, or you would like them to have lower voting power than you as a founder. Famous example, I think it was Mark Zuckerberg, Facebook. Zuckerberg owns minority of shares in Meta or Facebook. Well, at least it was so at the early stages, but he has majority of votes because his shares are special, giving them, I think it was 10 or 20 votes per each share, whereas other shareholders have only 1 vote per share. This is nowadays possible in Latvia, and as I've written there, almost anything goes. And keep that in mind. And you might want to have, and I've seen companies like that here in Latvia that have 3 different categories, or 4 or 5. One for founders, one for special, say, top-level employees, and one category for kind of lower level or employees. For example, founders get rights to vote, get rights to liquidation quota. Another category gets, say, 1 vote in the shareholders meeting, right to a dividend, and another category gets only the right to dividend. So when it comes to shares, what are the most important rights associated with shares is voting in the shareholder meeting, right to a dividend, and right to receive a liquidation quota, which is how you split up everything if the company is dissolved. So, but in any case, dividends and voting rights, those are most important. And these can be divided however you want. So this is something to consider when establishing a company. And as I said, almost anything goes. Finally, the matter of UBO. Why am I laughing? Because sometimes it's really, really complicated. So according to Latvian law, each company needs to disclose their ultimate beneficial owners, or UBOs. If you are two natural persons, you and your partner, or 5 or 4, this is not a big problem. You just say in the documents that I am a founder, I own this amount of shares, so me and my other partners, we are the ultimate beneficial owners. However, if an investor comes and say it's a fancy VC fund from the United States, which has a really complex legal structure behind it, this can become a hassle. So this is something for you to bear in mind. And if you are considering outside partners, this can become a bit of a hassle. So a piece of advice here, remember about that. Remember that it can be burdensome because the company register will really dig deep into each company's structure. And if you have founders that are really not willing to disclose to Latvian authorities, well, not founders or investors, that are not really willing to disclose their full structure to the Latvian company register, it can be a problem. And it can become a problem actually at the really final stage of investment when it comes to just filling up the paperwork. So kind of remember that if you see a fancy investor, ask them, hey guys, have you registered in Latvia before? Have you gone through this process of registering UBO? You know, it's a bit of a hassle here in Latvia. Do you have advisors that will help you? And if they say, well, no, but it should be easy, then you can ask them, okay, guys, let's get ready for that so that this is done. Yes, please. Yes, exactly. PLG, patiesā labuma guvēs. Right, so this can become a hassle in Latvia. And Latvia, I think I would dare to say, is actually paranoid on this one. Meaning the company register asks all information, it is all published online, and they request the so-called documental proof. Why am I saying this? Because there have been some instances where this is kind of a nightmarish situation for us to handle. Right. So let's get a bit to the gist, what to write in the founder agreement, and as I said, share articles of association. First and foremost, shares. Already touched upon that, how many shares each founder will receive, what will be the rights associated with them. Again, you can have different categories, different rights, different voting powers, or no voting power for certain categories of shares. This is, as I said, almost anything goes. Not anything, but and this is where you can actually take an example from fancy American startups and build kind of a similar structure. Just remember, it's not just the founders agreement where you have to write it, you have to write it also in the articles of association. Governance of the company. Company is governed by the board. Who will be on the board? Who will be actually the ones running the company? In USA, they have a bit different structure. They have officers like CEO, CTO, COO, and then they have board. And board is more like functions more like representatives of shareholders that look how CEO are performing. In Latvia, it's a bit different. You have board, VALD, and they are responsible for running a company. Because board and shareholders, at the early stage, it's usually the same persons. The founders are on the board, but at the latter stages, when the investor comes in, that will probably be not actively involved in the management of the company, but you will have to perform as a board member with actually quite a great liability towards the company. Please.
What about padome?
Yes, so padome is supervisory board. It is not required for limited liability companies. Padome is responsible for representing shareholder interests and overseeing how the board works. If there is no supervisory board or padome, then the same function is fulfilled by the shareholders meeting. And in Latvia, shareholder meeting can interfere directly with the board, and they can actually kind of manage or make decisions on behalf of the company in place of board. So there is a way that shareholders can actually directly become involved, but we are talking about majority of shareholders. Investors usually don't have majority stake in the company. They are usually not interested in managing the company, but if you give away majority of your equity, understand that any point, unless you have provisions in articles of associations or agreements, the shareholder meeting can come, say, change the board members or start making decisions in place of board. Because shareholders are kind of main persons in a company in a sense that they have the financial interest in the company. What to remember about being on a board on a company as a founder. So what it will typically look like, an investor will come, they will ask you to keep running the company, be on the board of the company. And being on a board is actually quite a bit of a liability burden because Latvian law is rather strict. Basically, you will be liable as a board member for anything except clear business risks. And this is real. Companies have gone against their board members. This is usually done that the action is brought by shareholders on behalf of the company, and actually minority shareholders can do that. I think it was 10% that can initiate action against board members. So a piece of advice, get insurance, liability insurance. If there is an investor on board, agree with them that you will have some kind of indemnity or liability insurance to protect yourself, your family, your financial interests so that you don't lose everything. So it is either an insurance or an agreement which basically says that if you as a board member have done everything diligently, you will not be liable for, say, damages you have caused to the company. An example of a court case where I was involved in, the board manager concluded rent agreements on behalf of the company, which were below market price. Say, he rented out company's premises on about, I think it was 30% lower pricing than the average market price. And his argument was, well, there were other interests, etc., etc., etc. Shareholders said, well, no, you are actually squandering away the company's money, and shareholders won actually, and then got compensation from the board on behalf of the company. So this is kind of a severe situation in my opinion, but this is how the Latvian law works. If you are insured, then at least this claim can be compensated from insurance company. It doesn't fully protect you, and you all probably have had experience knowing how willing insurance companies are to pay out compensations, but nonetheless, please consider that. Founder agreement is something where you could write special voting arrangements that you might have with your co-founders. And let's talk about what actually you need to think about when writing a founder's agreement. So again, a founder's agreement can be very complicated, but in essence, what you want to do is put yourself in a mindset, okay, what happens if tomorrow my co-founder becomes my fiercest enemy? In a sense that we completely disagree on future way how the company goes, how we will resolve that. Ultimately, of course, everything goes to the court. But please consider how we will split future shares. Do either of us will get a right to appoint a specific board member which we trust individually as a founder? If we have a 50-50 split, what happens if for, say, 6 months we cannot agree and we cannot adopt a shareholders meeting decision? For example, we can't approve the annual accounts because we disagree on everything, and in principle, my co-founder will go against everything that I want. How we will resolve such dispute? And there are ways how to resolve deadlocks, usually involving mandatory kind of obligation for one shareholder to sell to another. For example, an agreement could be that if for unreasonable period of time, one of the shareholders does not make, say, decisions in the interests of the company, then the other shareholder has rights to buy the other's shares for par value. Usually that means below the market value. This is fairly complicated, but this is where to put it. So governance of the company, new equity, think about how you will make decisions on attracting investors. For example, you are happily, you go to VCs, there are 2 VCs that are ready to fund you, but you completely disagree which one you will take. You'll like one, your co-founder likes the other. How you will resolve that dispute? What will be the time limitations there? So these are things to consider. When an investor comes in your company, they will likely want to have their special provisions. So be prepared that your simple company with clear, say, boundaries between your co-founders will get completely overhauled. An investor might come and say, okay, we want this. Please change your founders agreement. Please change your articles of association. And by the way, here is the shareholder agreement that we will want to conclude. So be prepared that that all of this is completely changing. One thing is to have a company where you are with your co-founders, with your friends. Another thing is when an outside capital comes in. And this is the time to actually lawyer up, to be a bit, well, if not aggressive with your investors, but to actually negotiate with them. And the most important aspect to negotiate is obviously because capital investors will usually come with certain percentage, and they will want to have kind of anti-dilution rights or certain priority rights over other future issue of shares. So this is something that you have to think about. Okay, now I have this investor. What will come at a later stage after, say, angel or seed investor? What will happen if our company will grow and another investor will come in and that new investor will bring in considerably more money? Say, first investor comes, gives you 1,100 euros and gets 20% of equity. The company grows, Series A investor comes in with, say, 2 million, but will get only 5%. And actually that previous investor will also have rights to that future issue. So you have to think one step ahead. When you make today your company, think about how you will present that to the first investor. So first investor would like to see something simple, so that they don't have to do expensive due diligence, hire people like me to go read through complicated stuff. They want it simple. After that, think about what will happen, and then your interest as a company when an investor afterwards comes in. You don't want your existing investor to get future issue of shares on a more favorable terms than the new investor. And if, for example, you have an agreement with the investor that says, say, we will always get new future shares paying only par value, or paying substantially less than any other future investor, a future investor might come, look at this founder's agreement and say, guys, I'm not investing, because you have existing investor who will come and just simply take away all the shares that you will issue, and we will get nothing. Well, if not nothing, or lower percentage. Yes, please.
The
Right.
What we okay, we agreed with the founder 50/50,
Mm-hmm.
and we can agree to sell our part of the shares to some investor or sort of, but I don't understand how new shares.
Right. Yes. So there are two ways how, for example, I can get shares in, say, your company, or you and your co-founder's company. I can go to you both and buy shares from you. What is the problem here? Me, as an investor, I want a stake in the company, and I'm willing to pay for that. But my primary interest is actually to give money to the company so that it can grow and operate. But I'm actually giving money to you, which you may use for the company, but you can buy a new car. And I don't really want that. I want my money going in the company. So an alternative, company issues new shares, and I am, well, in Latvian law, it's not really buying, but let's call it buying, and I'm buying shares from the company. And imagine you have a company with share capital 2,800. I am willing to put up, say, €1,000,000, and we agreed that for 1,000,000, I will get 20% stake. So that creates a problem. You have a considerable stake to keep, but very little money in the company, and that's normal. I'm willing to put in a lot of money in the company, but you don't want giving me absolute majority of voting rights. Imagine, I say, in a normal situation, that would mean that my stake would be 1,000,000 and yours would be 2,800, and that would mean that I essentially completely control your company. You don't want that. You want to keep yours. So how it would usually happen, a company would issue new shares, and I would have to pay a premium on those shares to acquire them. So you would issue 20 or 30 or whatever new shares up to the percentage. I would have to pay the par value plus a premium, all the money going to the company, but getting only those 20%. So the par value is essentially that amount that kind of determines stake in the company. So company can have, company has a capital, share capital, registered one, and company has shares. And for example, a company with capital 3,000 euros can have 3,000 stakes with each share being par value of €1, or say one share having a par value of 3,000. So the amount of shares and par value together determine the percentages, voting powers, etc., etc., etc. And this is something you can play with. And this is completely up to the founders or shareholders of the company to decide. Usually you would want to have 2,800 euro company with say €1 with €1 with 2,800 shares having a euro par value. There might be considerations why to have them a bit higher because later on, but that's a bit too complicated why to do that. So, and an investor coming in with the money needs to pay that par value to get shares, but they can pay a lot more. And this is considered a premium. And that premium also goes into the capital of the company, but it does not become part of the share capital. It becomes a different position. So this is something important because again, you might want to have an investor putting up a lot of money in the company, but not getting all the voting rights. And this is something where the math will kick in, where you will need to calculate that. What else? Yes, so another important aspect, and this is where I'm diluting a bit between founders agreement and shareholders agreement, because it can be in one agreement or the other, but essentially I'm going through kind of like the important things. Another thing that investor will likely ask from you is to have a shareholders agreement. Shareholders agreement, which is a bit different on founders agreement, because founders agreement is something that is agreed between the shareholders, and the aim of it is answering the question, how will company be run and governed? Shareholders agreement aim is to govern relations between shareholders individually. And this is where an investor will likely, for example, an investor putting up a lot of money in the company, but getting, say, 20% stake, which is kind of normal, they would want to have a board member acting on behalf of their interests on the board of the company. So technically, they have only 20% stake. Founders have 80% stake. So founders technically at any time can appoint a board whatever they desire because they have the voting rights. But an investor says, well, I'm completely fine with being a minority owner, but I want to have that one person on board. So the solution here is have a shareholders agreement between the founders and investors saying that founders can appoint, say, 2 board members, an investor gets to appoint 1 board member to act on the board of the company so as to keep in touch with everyday actions of the company. Another thing that investors will usually ask, they will invest money in the company, but they will say, dear co-founders, we want you to stick with the company. We don't want you running around establishing 3 more startups. We want you fully interested in this company. So we would like you to, say, not be able to sell your shares for, say, 6 years to anybody, and you have to remain at the management and shareholding of the company. Because, for example, at some point, an existing co-founder might decide, I've had enough of this. The startup world is completely crazy. I'm selling my shares to somebody outside. Investors will not want that because they're essentially not investing in company. They are investing in you as co-founders, and they want you on the board. So they will likely ask you, say, let's put in restrictions in the shareholders' agreements. What will happen if you would want to sell your shares? For example, for 5 years after the investment, if any of the founders find a purchaser for their shares, the shareholder, the investor has rights to jump in on that deal, or has to approve that deal, or has rights to jump in that deal and buy all your shares for €1, so as to keep you in the company. And this will something that will be likely asked by investors. And this is something that you will have to understand, keep in mind, try to negotiate if that's against your interest, but likely uh, the investor will be adamant on this one. I went through with Printify with their Series A financing, the one with Index Ventures years ago, and this was something of a red line for investors. They wanted existing management on board for X amount of years, and that's it. And this is their boundary. We don't want Printify unless James is running it. This was their position, and that's it. So there were certain hardcore agreements how to keep that happening, and this is what likely will happen also with you. And this is where you would want to protect yourself. So again, good question, actually. So this is something to negotiate. But what will happen if you would try to push me out of my company? Usually it's not that easy, unless you have agreed to some exuberant amounts. And this is where you would actually go to investor and say, okay, you want me in, fine, I will be in, but I also want some kind of protection for you pushing me out. Either we have a situation where I'm the majority shareholder and I can always block a decision on me being pushed out, or there is some kind of compensation if you would want to do that. Okay, fine, I can go, but you will need to pay me whatever amounts. They can't really push you out from the company, meaning that you lose your shares, but they can push you out from the management. Because again, unless you have special protective provisions, yes. They can't confiscate your shares because that's your property. Property rights and capital is more sacred. But the commercial law is clear. Board member can be removed by a lawful decision of the shareholders meeting at any time without no reason at all. In limited liability, look what happened with Mr. Gauss and Air Baltic. There is a technically requirement in the law when it comes to corporations like Air Baltic, which is a different form, akciju sabiedrība, that there must be a reason, but actually there needs to be no reason at all. This is a sacred right of shareholders to decide to remove board. I think the famous example was with the Ford, who removed the guy whose name I can't remember. He was the CEO of Ford, who built Mustang, everything, like built the Ford to a company that it was, and then Henry Ford II decided to remove him from the CEO position, and once asked why you did that, he said, well, I didn't like his handshake. I mean, obviously an anecdote, there were other issues, but this is reason enough for shareholders to decide to get rid of board members. Same goes on the other way. The board member can actually resign from the position. This is something actually that, according to Latvian law, cannot be really kind of protected against. Any board, forced labor is prohibited. If a person does not want to be on the board, he can go away at any time. There is no actual cue from that. But in any case, so this is something you will probably kind of have a contention point with your investors, how to protect each other's rights, what will happen when other investors will come, will there be any special voting rights? Also, investors will ask you to probably to establish the stock option pool of at least 10% from the company's equity. This is a standard one. So these are the issues. I'm trying to remember from my experience with investors, what are their usual kind of things that they look at the most. They want protection against founders leaving the company. For example, saying you must remain on the board of the company, and if you don't, you can't sell your shares for a free market price. That could be a provision in the founders for a certain period of time, say 5 years. They will want to have certain priority rights over next issue of shares, And this is something where you really will need to take a real hard look and really negotiate with investors and really understand what's written in the, and usually these changes, these founders agreement, shareholders agreements, they are proposed by investors, lawyers, and this is the time to actually lawyer up, call somebody and say, let's look at what's written here. And not what the investor is telling you, what they mean by this, but actually what is written here. What will happen when another investor will come, or you would want another investor to get in the stake of the company? Is there anything in the agreement saying that existing investor, meaning the one you are negotiating with right now, has some kind of priority? Do they have rights to block certain decisions? Because investors might want to be kind of you running the company, but they might want to have certain blocking rights. For example, they could say, we are happy with you making business decisions, but when it comes to a decision of issue of new equity, we have the blocking rights. And this is where you would want to be tough on them and say, guys, I will go around and try to get other investors. If you have blocking rights against me making a decision to issue new shares, I will not get any investor. Let's negotiate. Let's put in a procedure. Fine, I'm okay with you approving or disapproving with investors, but you can't outright block them. Or let's agree that you can block it for 1 year, but not for indefinitely. So again, think one step ahead. Existing investor, completely fine, but what will happen if the company grows? You will need additional capital. Existing investor is simply just an angel. They have the monetary capacity to give you 100,000, but you want to attract 50 million because you have the scale, the growth potential, everything. You need to hire 500 professional IT people, get a fancy office, and you know that you will conquer the world, but you can't do it because the existing investor has some kind of protectionary provisions in the founders agreement that actually prevents you from doing that. Meaning that other investors looks at that and says, no, guys, unless we get completely on board with the existing investors, I'm not going with this. So just I'm not saying investors are bad, but clearly read and understand what they want and what is written there. So I would imagine this gets really confusing, convoluted, and everything, and it kind of is. Just remember, protect your shares, protect your stocks, think one step ahead. And when it comes to this really comes of importance when you get a funding round. This is important. And finally, a little bit about stock options and personal stock. This is where my colleague will take over and tell you more about taxes, but essentially stock options, as you may probably know, are rights to purchase company shares in future for a price that we determine right now. Meaning, when you give a stock option to your employee, you essentially grant them a piece of paper saying, dear employee, after 4 years, you will be able to buy X amount of company stock for Y amount of price. Usually that Y amount of price is 0 or rather low because it serves a kind of as a compensation. When giving out stock options, you want to keep those employees for certain time. So there is this thing called vesting period, meaning today you give stock options to employees, but they get to exercise their rights to purchase shares in the company only after certain period. The standard provision is 4-year vesting with 2-year cliff, meaning, dear employee, I will giving you 100 stock options, giving you rights to buy 100 shares, work for me for 2 years. After 2 years, you get the right to exercise get the right to purchase for, I don't know, 1 cent or 0 euros, 50 shares in the company, and thereafter, for each month you work with me, 1/48 of that 100. So this is kind of a standard provision. This can be different, can be changed, but pretty much an industry standard. Price can be as low as 0, contrary to America. In Latvia, very liberal, actually, stock option regulations, and almost anything goes. Usual pool requested by investors, 10% from the share capital. Who gets them? Not only employees, but could be your consultants. You have a high-flying business person that is willing to give you, say, 5 hours of consultation work per month. You don't have an ability to pay them in cash, and he or she is willing to accept payment in stock options or outright stocks. So this is also something that you can do. Basically, it's the way for you to buy high-level work of high-level employees by not paying them in cash, because obviously any startup is not really cash rich. You are rich with ideas, with potential growth, hopefully, but not with cash. So, yes. Any final questions before? Yes, please. Right. So in Latvian, you need to have, in Latvia, you need to have in Latvian those documents that will be submitted to state institutions. Articles of Association, Founders Agreement, those are submitted, and those will need to be in Latvian. They can be in English, but officially translated. Usually, they are made bilingual by lawyers working with both languages. In any case, if the case goes to the court, the Latvian language version will be considered as the one authentic. And although you will say that originally we developed it in English, but only did the translation to Latvian, actually the Latvian language will be kind of the prevailing language. So negotiate in English, but write in both languages. Please.
Thank you. And then if the investment fund is one of the shareholders and then they use the rights that you mentioned, so they lobby an opportunity to keep a board member as a board member for 4 years, but then it's in their own interest to have an earlier exit in the 3rd year. Don't they block themselves, or what happens in such cases?
Well, this is something you will need to agree specifically in the agreement, what will happen. But I would imagine if I would write an agreement, and usually it is written, so if an investor goes through an early exit, then obviously the board member is then free to do whatever amount, meaning that any rights of investors associated with company terminate at their exit. If you're not a shareholder, you need to lose all those rights. And that actually needs to be explicitly written in the agreement.
And the same with options for employees. So they are, for instance, in 4-year horizon. And then if an exit happens in the 2nd year, then what?
For you to have options, you need to have an option plan in your company, meaning a rule book for options. And in that rule book, you have to foresee what happens if the employee does an early exit. Usually with standard 4-year vesting, 2-year cliff, if they decide to leave company after 3 years, they get the right to purchase shares that they have accumulated over that 3-year period. And then after that, they just become shareholders. My personal example, I worked with Printify. Part of my compensation was options. When I decided to leave company on good terms, I exercised my rights and I became a shareholder of Printify. So now I'm no longer with Printify, I'm not an employee, but I'm still a shareholder.
Yes, what I meant is an exit of the startup itself. So if it's resold to
Oh,
another
okay.
entity?
Yes, a really good question. And this is usually a very important part in a stock option plan or stock option agreement with your employees. What happens if company goes public or is sold? Uh, Usually, as an employee or as a co-founder, you would like to have in the stock option agreement or plan the so-called accelerated vesting, meaning that if an exit event happens, an exit event being either IPO or wholesale to a huge purchaser, then all stock options automatically vest to the full, and employees have rights to acquire shares in that new company. And this is something investors might actually not agree with that, but this is where you would like to probably, because me, if somebody from a startup would come to me and say, hey, Kaspars, become our lawyer, we can't pay you, but we will give you a ton of options, I would carefully look at the option agreement, the option plan, and that would be one thing I'm saying, guys, I'm not agreeing to that unless I have this accelerated vesting. If, for example, tomorrow you get to sell your company for a huge amount to, say, Alphabet, Google, or whatever, I want to get that compensation in full. So, but again, this can be or cannot be written in the agreement. And keep that mindset that there are certain standard provisions that are in the market, like options, vesting periods I've described, but there are certain things that can be different, and accelerated vesting is one of them. There are companies that have them, and there are companies that don't have them. So up for negotiations. Pretty much a market standard is founders get shares with higher voting power. They keep the control of the shareholders meeting. Investors get a different category of shares. They have priority over any dividends, if any are paid. They have certain blocking rights, meaning they get to appoint one board member. They get to block any future issue of shares unless they agree to it. And they have certain provisions with you as a founder, as a board member, that gives you a huge incentive for you to remain with the company. Remain with the company meaning as a manager, not as a passive shareholder. These are the most important things that they will have there. And this is something where you will need to or would want to negotiate with them.
If the initial documents that you mentioned, like founders agreement and so forth, are reviewed later, can everything be changed?
Yes,
or
they can. Yes,
except
everything
for
can be
the
changed.
registration number of the company?
Yes, even the
Yeah.
name of the company can, actually, yes, the registration number can be changed. But again, why, for example, is it important for investor? Say, I said to you at early stage, keep it simple. Because you will go with your company to an angel or seed investor, and they have like 50 meetings per day with people like you. And they basically just look at your 5-10 minute pitch, and they essentially decide on the spot. If after that first handshake looks good, we're giving you 100,000, you go to them and says, okay, these are my articles of association, this is my founder's agreement. They will look at that and say, okay, lawyer's fees coming right up because there's a huge amount to read. No, please go away with that. Instead, if you go to them and say, I have standard provisions, this is my one-page articles of association, this is my one-page founders agreement. If you want something special, please give a draft to me. Let's agree on certain market standards. And they will be, okay, this looks good. And then they will look at you from business perspective. If you have a company, I don't know, producing essentially something intellectual property like an app, which is a code and intellectual property, they would want that, okay, have you registered everything? Do you have agreements with your employees? Is that protected? Oh, by the way, yep, those looks good. let's go with the investment. Keep that in mind. As I said, don't overcomplicate things where it's not necessary.
As the name suggests, the liability is limited, but you mentioned insurance for the founders. Without the insurance, what is the ceiling of financial liability on a founder?
We have to play with the boards here. When it comes to limited liabilities, rather, we're talking about risk aspect. How much money are you risking with when you establish a company as a shareholder, as a founder? And you risk only with that amount that you put up as a share capital in the company. If that's gone, it's gone. Board members can be a different person, but you as a shareholder also can be a board member, and they have a fiduciary duty, that's the fancy legal word for it, against the company to act as managers, as prudent managers. And if the board member fails to do that, the company can claim damages from the board member. And this liability of a board member is unlimited. So if you are the sole founder, shareholder, and board member, this is a non-issue completely. But if you have investors, they can go against you, not as a shareholder, but as a board member.
Thank you. And then, are there any cases when you would not suggest, recommend giving shares to investors? So any domains or types of economic activity when it's crucial that there are no venture funds having shares in your company,
Well,
but it's only with the founders?
I mean, I think not talking about outside investors goes against the whole idea of startups, because what essentially are startups? High growth companies that lack capital. And the capital is, and the venture capital is the ones willing to give that capital to fund the company. If they're not getting any shares, what's the point of them giving the money? So
yeah, we wanted to apply to an accelerator in Central Europe, and then the requirements was that the founders own at least 90%.
right.
And then the remaining 10 were very strictly regulated that if there are venture capital funds, then those that are outside of Europe can own at most 2% of the company. Otherwise, you're not admitted to the accelerator.
So this is the requirement of that particular accelerator.
Yeah.
Can't really know why. Probably because they receive funding from European Union funds, and European Union funds wants to keep the money within the Europe. So probably this was part of how they get their money, meaning that there was an interest from the European Commission that the money stays in Europe.
Types of startups, something else, and CR is referred as a company. Like registration, for instance, we refer that young and
It's right. It's that it still remains the same type of company. It's just the status that a company gets, meaning it gets certain advantages, but essentially it still remains that same limited liability company. Technically, yes, you can choose different forms. You can even become a joint stock company, but from practical perspective, you will probably go with SIA. Can't really see specifically for startups, why would you have to want the hassle to establish a joint stock company that has a minimum share capital of 25,000 euros, if I'm not mistaken, that has this supervisory board mandatory, meaning at least 3 people supervising, so just a bit too much administrative hassle. You will likely choose this company and perhaps apply for this startup status.
Yes, thank you. And um, what is the right moment to actually found a company? And the reason I'm asking, because we've heard some horror stories on the liquidation side of the company that
Right.
is much more difficult. And we have some schoolmates at Start School who keep paying for an existing non-active company
Right.
every year because it's still cheaper than start the liquidation process. Are there any underwater?
So usually you can't liquidate of the companies because of some tax liabilities or not being complete. Well, there are either tax liabilities or the company has not done all of their tax returns, and that prevents them from liquidation. Another reason can be that the company is actually insolvent, so it has to go through insolvency process, which is an additional expense. Uh, I would suggest establishing the company right at the moment where there are more than one founder, when you have decided to put up certain money for the whole project that you want to build. But this is me as a legal person speaking that always is thinking about liabilities, different interests, because company gives you a clear framework how it will operate with the money that you will put up. You can do it with your co-founders, with your friends, without establishing it. But I'm always thinking, what happens if people start to argue? What happens, or rather, actually, from practice, it's not that people don't lose their friendship or become enemies as founders. Usually, the kind of discourse starts at the moment when the big money arrives, when first or second investor gets in with a huge pile of cash. And this is where disagreements can pop up, how to do it. So uh, don't be afraid to establish a company, have an accountant that diligently files all the tax returns and everything, keeps an eye on solvency of the company, and as soon as you see that, okay, this is not going well, the company is not growing, we want to get rid of it and establish a new startup, make sure to liquidate it. Because if you are solvent, meaning there are no huge outstanding liabilities, then you can actually liquidate it fairly easily. Just keep an eye on that. That's what I'm actually stressing. Have a good accountant that you are completely sure that all the returns, everything is filed, all the taxes are paid on time, or you get a deferred tax payment, or have an understanding that if you are willing to stretch this risky business, that if it becomes insolvent, you will actually be able to go through insolvency process. For example, in Germany, if you are a shareholder or board member of a company that becomes financially insolvent, it is a duty of management to start insolvency under threat of criminal liability. It used to be so also in Latvia, but not anymore. So keep an eye on that.
And the accountant, for instance, most of us are in the stage of building MVP, so writing a code without any cash flow at the moment. And if we register a company tomorrow, do we actually need an accountant tomorrow, or towards the end of the year, or
How is it, Victoria, when the accountant really becomes necessary? At the end of the year, definitely.
I would suggest that you have an accountant already at the beginning because you have to submit your tax returns on a monthly basis and have a good accountant which is insured because the accountants, also certified accountants, have to have the insurance, because if they are doing something wrong, then you receive the payments about their failures. Don't definitely wait till the end of the year you have to have it immediately. Or you can do it yourself, but if it's like, yeah.
I wouldn't try to do it. You might.
Yeah, it's actually the accountancy part is really like pain in, as Kaspar, you said, in certain part of your body. So yeah.
Yes. Southern side of your body.
Be sure to have a good accountant.
Thank you. So basically, it's within the first month because you have to fill it for the first month, the accountancy statement.
Yeah, you have to fill the tax returns
Tax
already. Yeah.
returns, yeah.
Yeah.
Regardless of whether you have any revenue or not.
Yes.
Thank you.
Okay, I think I've overextended my welcome. Time to
Yeah,
give.
very extended. Kaspar,
That happens.
do we need a break?
Okay, it's 11:45. I hope you had a chance to grab a drink before we continue. And let's continue with the second part of today's session. And just in case after we'll finish the presentations, you will have a chance to approach our amazing speakers, Victoria and Kaspars, to have like a private conversations about your specific questions until 1 o'clock as well. So let's start. Victoria, thank you for joining us.
So this dramatic phrase belongs to Benjamin Franklin. My name is Victoria, and I'm not so dramatic as Benjamin Franklin. I actually, in my 20 years, almost 20 years in taxes, believe that taxes are fun. And not a single case is the same as previous one. And we need to talk about taxes because each government needs taxes. We need to finance our teachers, our doctors, build another fancy bridge across Daugava. So the government wants us to share with them all the earnings we have. And I need, guys, your help in my presentation because, as I said, for almost 20 years, I work with taxes, and I tend to think that people understand me, people know everything about taxes, and if you feel that I start to talk gibberish, please interrupt me and ask questions. And we don't have much time for my presentation left since Kaspars couldn't shut up about his topic. But let's start. I will try to explain a bit like basic of taxes. Janis told me that you have a huge, amazing plans, and big, huge investors will come, and you will have a lot of millions in your turnover. So I will not tell you about like small tax regimes like self-employment or micro taxes. Therefore, we'll start with the normal taxation. So once you start up your company, you registered it, you have to start to pay taxes. And there was like a previously a question, when do I start up my company? When do I have to register, etc., etc. But actually, once you start to perform any economic activities, the government will see you and they would like to have their share. So if you start to doing your business, then it's actually, it would be great if you could register your company before you actually start any like major economic activities. Our tax authority in Latvia, they are friendly. They will explain to you different tax rules, but please don't consider them as your friends, as your best friends, because they will find you and they will want you to pay taxes. And for corporate income tax, we, together with Estonians, have great corporate income tax, which is actually zero. And for example, you have a profit, well, you have you have earnings, you spend some you have expenses, and you calculate that you have a profit. And if you reinvest this profit in your further activities, the corporate income tax is zero. But once again, this relates only to Latvia and Estonia. If you start to work in any other country, be sure that they will tax annually you on your profit. So in Latvia, our corporate income tax is zero. Unless you want to take out this profit in the form of dividends, then in this case, the government says, oh, you want to have your dividends, then in this case, please pay us. And the official tax rate is 20%, but actually you have to divide this amount by 0.8, which brings us to effective tax rate 25%. So once you start to distribute dividends to yourself as a shareholders, you start to pay corporate income tax. The same applies to unrelated expenses. Let's say you have a profit and you reinvested it in the other activities, and you don't want to distribute dividends, but you decide to go to Bali on a business trip. In this case, if you don't prove that this is indeed a business trip, it will be qualified as business unrelated expenses, and in this case, you will also have to pay corporate income tax. So be sure to have all the proofs that all your expenses are related to your business. So far, so good? Yeah, okay. Then the next tax is personal income tax. And personal income tax is payable by each of you individually. So corporate income tax is paid by the corporates, and personal income tax is paid by you individuals. The simplest example would be salary. So if you have salary up to 105,000 euros, you will pay 25.5% personal income tax. If you are lucky enough and have a higher salary, then our government wants more taxes from you. It will be 33%. But if you earn more than 200,000 euros annually, you will have to pay additionally 3% on your personal income tax. It could be relevant to you if you have like high performers in your company and want to reward them. But these 3% are paid by individuals by submitting their annual tax returns. If you are employer and you are withholding this personal income tax, then you will withhold only 25.5 or 33%. It's, yeah, we are like a fancy countries. We want to have a progressive personal income tax rate, but you are lucky that I'm not explaining you personal income tax that was last year, because then we had the 3 brackets and mysterious non-taxable minimum, which nobody could calculate it except Latvian tax authorities. So this year it's a bit easier. And personal income tax, again, we pay as individuals all the time. Everything is taxable except some minor things which are non-taxable. So if in doubt, pay taxes. Social tax, actually I'm naming it social tax for you to better understand, because everybody calls it a social tax. The proper way is social security contributions, which we contribute into our pensions, maternity, paternity benefits, and this is calculated only from your employment. So your salary is subject to social security contributions, and you as employer will calculate those contributions on each of your employee. So the social security contributions rates are actually different depending on the status of employee. This is a general rate for like general employees, but if you have like senior age employees which receive pension, then the rate will be a bit lower. And the social security contributions is divided by employee and employer. 10% is withheld from employees' gross income, while 23% are calculated on top of gross salary and paid by employer. So when you calculate your employees' salary costs for you as a company, you will take employees' gross salary plus 23.59% social security contributions, which are your costs. So your costs are gross salary plus 23.59%. Each company, especially newly formed, is required to have at least one employee who is receiving minimal salary, which is 740 euros per month. If you don't have any employees which receive at least minimal salary, then you as a shareholder are required to pay minimal social security contributions and personal income tax from at least one minimal wage. Gibberish? No? Okay. Yes?
So if you don't have we pay at least 23.59% of the minimum salary in Latvia monthly.
Not exactly. Not exactly. So if you don't have employees, or you have, for example, like 2 shareholders, yeah, you don't pay yourself, obviously, a salary. You are working for the benefit of the company, and you want to take out dividends later, because if we compare 25% and the social security contributions and personal income tax, then it's for you more beneficial to live from dividends. But the government says that in a month, you have at least the turnover of 5 minimal salaries. In that month, if you don't have any employee who receives at least minimal salary, you will have to pay both personal income tax and social security contributions from one minimal salary. It also is known as board members minimal tax. Maybe you have heard it. And the good news is that this is not applicable for the first and last year of company. And this rule works only in calendar year. So for example, if you form your company in November, then you will enjoy this regime only for November and December. But if you start your business in January, then you can enjoy this for whole 12 months. So from tax perspective, it's better to start your company in January. I understand that this could be like complicated, difficult, but we have a Ministry of Finance homepage. You can Google it. And actually, in the first page, they have this nice and beautiful Excel where you can put in your like gross salary and it will calculate all the employment taxes for you. So that way you are sure that you are calculating taxes properly. The social security contributions are capped to first like 105,000 euros. So after this amount, when it's reached, you don't have to pay the contributions anymore. However, I know that people don't like that consultants continue with the word however, but still, however, after this you start to pay solidarity tax. And I don't want you to freak out. I will not tell you about the solidarity tax. Once you reach that point that you receive such a high salary, I'm sure that somebody will explain to you what is solidarity tax. It's really complicated. But in this Excel that is available at the Ministry of Finance homepage, it will calculate solidarity tax as well if you start to receive such high salary. And then we have a value added tax, VAT. And you have to register for VAT tax purposes once your turnover is more than 50,000 euros. And then you have to pay, calculate, etc., and report value-added tax on your services. Each of this topic, each of this tax is actually separate world. I could talk for ages about each of them, but this is like indeed very, very basic. And I have this link for you. Maybe Yanis will share this presentation with you so you can access this link because this is like first steps to entrepreneurs, which is published at Latvian Tax Authority's homepage. And it is available in English as well. So this link is to this English page. So a bit more about each of those taxes. Yep. And then we have this nice startup regime. If you apply for the startup regime, there are certain advantages for you for tax purposes as well. The first steps for these qualified investors, etc., this is managed by LIA. So you don't get automatically this startup regime. You have to apply for it. And I'm not an expert on all these fancy benefits which are available from the government. The only thing I can tell you is that if you receive this permission to apply startup regime, then you have fixed social security contributions amount, the amount which is subject to social security contributions. So you pay contributions to from your employees from 2 minimal wages, which is 1,480 euros plus the rate. So you don't pay the contributions from the whole amount, only for twice minimal wages, and you don't pay personal income tax. So if you want to apply for this, please do, and it will help you at least for the first year. And they also have a possibility that you can receive a 45% up to 45% of the salary of high qualified employees. So to compare, those 45%, yeah, it's for 12 months. Yeah. And I think that you can apply for extension as well. So I made a little comparison. For example, if you have a normal SIA limited liability company that has no benefits, tax benefits, and you have a turnover of 100,000 euros, you have 2 employees, and for example, office rent for 20,000 euros, you paid for some services for 5,000 euros. Then in the first case, which I do, have I? No, I don't have. Okay, the ticker. Okay, so in SIA case, you're from turnover 100,000 euros, you are left with 800 euros only to as a profit. But in case you apply for this startup tax regime, then undistributed profit is 6,000 euros. And possibility to receive 27,000 more as co-finance of salaries of employees. So I think you could consider applying for this regime. You have to prove that you have high value product with a huge potential, etc., etc. But I'm sure that if you upload the law in ChatGPT and tell you to prepare an application, he will do the job. But again, I'm not an expert on LIA cases. Of course, they would, most probably they would ask for some kind of business plan from you, but I think it's worth trying because you can ask for those startups who already applied for this regime. They could share their experience with it. It's yeah, I understand it could be bureaucratical, but the gain is significant. I imagine you can see it. So yeah.
Sometimes, sometimes it's not for more.
Yeah.
And startup is still a sub kind of SIA in this case, right?
The form is the same. It will be the same as a SIA. Yeah. You will just use this tax regime. Yeah. Nothing will change. The company register will still show you as a limited liability company. You just will enjoy this regime, and that's it.
Does it have to be decided up front, or we can first register SIA and then in the third month
Yeah,
transfer to
yeah.
start?
Yeah. Yeah, of course.
And when it was presented a couple of months ago, the Latvian Startup Association said that there are two options. So one of them is subsidies or reimbursement for highly paid professionals, and then there was an alternative,
Mm-hmm.
which I don't remember, but the entire point was that you had to make
A decision.
choice.
Yeah, yeah. It could be the case. Again, I'm not an expert on LIA cases, so I can explain to you how it looks from tax perspective. Yeah. So those startup guys most probably would know better. But again, it's a possibility to receive 27,000 euros. As an example.
How? How they receive? They just, you don't have to pay it, or you have to pay it first and then you get it back?
I think you have to pay it first and then you get. It's like a reimbursement. So, okay. Yeah. Okay. And the next topic is international aspects. Again, we can talk for ages about this, but yeah, Jans told me that you want to do your business with other countries as well. And the most important thing is that once you start to work outside of Latvia, you have to be sure that we have double tax treaty with this country. We tax people call it double tax treaty. The longer actually it's says that convention between blah 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 blah, also known as double tax treaty. We do have double tax treaty with USA, with the United Kingdom, with actually a lot of countries. So you could be safe when you start to work abroad. The double tax treaty, what does double tax treaty do? It's an agreement between two countries where they say that if the company, for example, is doing a little bit something in my country, we will tax partially what they are doing in my country, or we will not tax it at all. But once you start to do extensive business activities in the other country, then the situation could change. So it's worth to study the double tax treaty. They are plus minus the same. Some parts could differ. We have a quite complicated double tax treaty with the United States. And also, once you start doing business in other country, it is not necessarily that the double tax treaty will prevent double taxation. I can tell you from the experience, for example, we do have double tax treaty with Vietnam, nice country, which says that if an employee works in Vietnam for more than 183 days, we will not tax it in Vietnam. He can pay taxes in Latvia. But once the threshold is reached, he should start to pay taxes in Vietnam. But Vietnamese tax authorities, although the government signed this double tax treaty, they don't care about this double tax treaty. So in theory, the double tax treaty should prevent double taxation, save your business, etc., etc. But in practice, it is not necessarily that it works. So if you start to do business with countries usually outside of European Union, have a different culture, etc., please make sure that you understand the local taxation as well. Yeah, I'm sorry to tell you, but unfortunately it is not working all the time. It should work, but it is not. Yeah. What, sorry? Software, okay. Yeah. Mm-hmm. Mm-hmm.
We just receive money from the website for specific background. So we might be that most of our customers are in the States.
Mm-hmm.
So I thought that no, we shouldn't. Maybe I was wrong.
It's you can the answer to your question would be in also in double tax treaty, most probably in Article 7, which describes so-called permanent establishment. What is permanent establishment? What actions when you do would cause you to start pay taxes in the other country? And usually, generally, when you start to actively work in other country, for example, you are a shareholder, you go to USA, you meet the clients, potential clients, you sign contracts with them. In this case, you start, it is considered that you are starting business in that other country. And you have to start to pay taxes in that other country. The good news is that the permanent establishment means that you will pay corporate income tax only from US activities. So if you have clients in other countries, they will tax you only for those activities done in USA. In this case, what tax authorities do is, in case of an audit, they will come to you, they will ask all your email correspondences, flight tickets, and they will track you down. How long were you there? What did you negotiate? What contracts did you sign? And then they will calculate corporate income tax. It is not often used in Latvia, but it is very often used in other developed countries like USA, Germany. Again, the good news is that for countries like Germany, USA, and the other large countries, if you are a startup, little startup, most probably they will not be interested in you. Once you start to generate a significant amount there in that country, which is higher than we consider here in Latvia as a significant, then maybe they will start an audit of you. But this is not like some kind of pill from me that, well, don't generate income there and you will not be caught. My, as a tax advisor, duty is to tell you that you have to pay taxes from your first cent, yeah? But again, if you are not generating significant amount, most probably they will not audit you. Good for you. You have to pay taxes there as well. It will not save you. Here in Latvia, so what does double tax treaty also do? It says that in which country you have to pay taxes and how we prevent double taxation. Which means that this double tax treaty says that if you pay taxes, for example, you started to do business in USA, you concluded that you have permanent establishment, that you have to pay part or partially something in USA, then what the double tax treaty says that the amount of tax paid in USA can be credited against your tax liability in Latvia. Yeah. Mm. Mm-hmm.
They have companies or sort of in each country where they have received big profit from.
Permanent establishment is most probably they do have, but permanent establishment is a term we use for tax purposes. That means that it doesn't really necessary that you have to register a limited liability company in that other country, but you have to be registered as a taxpayer there. So most probably, Kaspar, do you know? I think that they should have something printify in USA if they have a significant par.
Well, part B, obviously that's the finance people when it comes to this one. Make sure that in some country where we, for example, would consider hiring people so that we don't become or do not fulfill these permanent establishment criteria. And what Victoria says is completely true. It's not a dead sentence. You register by your taxes, but it's an expenditure. You have to hire local accountants to do that. So this is something to really consider.
Mm-hmm.
And then sometimes you do that because income or other associated benefits outweigh that. Again, it's not a dead sentence. Okay, mostly people just need to do how other.
I had an experience with Sweden. They are very advanced in quoting those who do not register. And one the Latvian company, they just wanted to start a business in Sweden. They won some contract, and why not to earn money in Sweden? And in 6 months, they received a nice letter from a Swedish tax authority that, hey, we noted you. Please register and start pay taxes. So this company didn't even bother to find out if they have any tax obligation in Sweden. So they were like really, excuse my French, pissed off, writing to Swedish authorities that Latvia is not some kind of like Swedish territory. Why do you want me to pay taxes? So that happens, guys. Once you move outside of Latvia, please consider your taxes also outside of Latvia. And also, if you hire someone to do the job not on territory of Latvia, please also evaluate if this individual is not creating a permanent establishment for you in that other country. If it's some kind of like, I don't know, secretarial duties, lady in, I don't know, Brazil, managing your calendar, most probably she will not create a permanent establishment. But if it's some kind of agent who is dealing on your behalf, negotiating with the clients, or software engineer who is like exclusively doing only job for you and is like, and your business depends on him, in this case, most probably you will have a permanent establishment in that other country. But this is only for tax purposes, yeah? Okay. If somebody from you wants to read the double tax treaty, I can share how to do it easier because again, the tax it's plus minus the same with minor deviations. But I took the article from Latvian and USA double tax treaty, which is talking about the royalties. So you see on the other side, which is like text from ancient legal text, which says that royalties raising in contracting state and beneficial owned by resident of the other contracting state may be taxed in that other state. I'm sure you didn't understand a single word of it, yeah? So, but if you are putting the country's name in the text, it becomes a bit easier. For example, contracting state, we change to USA, and other contracting state to Latvia. And in this case, then we can see that royalties arising in USA and beneficially owned by Latvian resident may be taxed in Latvia. I think it's better to understand if you change the words to countries. And don't be fooled by the phrase may be taxed. It's not an option. Again, it's all ancient legal text. It means that if Latvia says that it will tax royalties, it will tax royalties. It means that Latvia just has a like first-hand right to tax this income. So for example, if you are a Latvian company and you are selling like royalties to USA, then you will pay tax from this income in Latvia. USA can tax this, but not more than 5 or 10%, depending on the situation. I think that Janis will share the presentation. Yeah, then you can read this nice, beautiful text when you don't want to sleep or want to sleep. Yep. That's really, really, really the most basic what I wanted to tell to you about taxes, pay taxes and sleep good, as they say. Again, a Latvian tax authority, they will consult you, they will explain to you. Don't rely on what they are saying to you when you call the free consultation number. If you want to have a reliable advice from them, please send all the questions in written via your electronic declaration system. In this case, then you can prove that the advice was given by you and you relied on that. One more thing is about the stock options and employee shares, which Kaspars told to you. We have, as I told that in Latvia we tax everything, but we have a special tax regime for stock options. It says that if the vesting period of these options is at least 12 months, during those 12 months, employee is employed within your company or a related company, and you have informed Latvian tax authority about stock options in your company, then later, when employees receive the shares, it is not considered as a taxable benefit. For example, if they, in generally, it would be that, for example, if the fair market value of one share is 100 euros and employee receives free of charge this one share, then you will have to calculate personal income tax and social security contributions from this benefit. But if you qualify for this regime and you have notified Latvian tax authority that you have these stock options, then received free shares will be tax exempt. And also, we have employee shares. I don't remember, Kaspar, you told about employee shares, no? It's actually widely used, not by startups, but with the bigger companies, but you can use them as well. So you give, for example, one personal share to your employee. It has no voting rights. Employee cannot sell it, pledge it, or whatever, do whatever he wants. He cannot do anything with this share except of receive dividends. And you can take back those shares whenever you want. So in case you have a profit and you want to share your profit with your employee, then you will pay only dividend tax, which is 25% effective rate, and will not pay personal income tax and social security contributions. That way, you can, for example, have quarterly or annual bonus paid to your employee without paying full payroll taxes. So it's nice tax saving possibility. But to implement this system, you have to be cautious. You have to take care about commercial law, labor law, and tax laws. So if you want to implement this, come to me and Kaspars. For small but fair amount, we will help you to implement this nice tax saving system. Any questions?
Maybe just coming back to example of Constantine's, if there is a website
Mhm.
and you do not come physically to other countries to start economic activity, you do not reach out proactively to any clients, it's just a website registered in Latvia or Estonia, and whoever comes probably pays a subscription fee. You do not even care what country are they from. Does it still qualify for paying taxes in every country where the customer comes from?
I'm not sure about corporate income tax, but again, each tiny detail which comes additionally could change the situation. But what I definitely know is that there could be the case where you have to start to pay value-added tax, VAT, because usually that tax is payable in your customer's residency country. I don't know, like example, I'm ordering something from Amazon, and they have a lot customers from Amazon. I don't know, in Germany, Amazon Germany. So when reaching the threshold of 50,000 euro, maybe even less, they are required to register here for VAT purposes and start to pay VAT here in Latvia. And it's the same in your example. So if you have customers, maybe you don't have to pay corporate income tax, but you will have to pay VAT there.
Yes, thank you. And do you have any advice on intellectual property, or would you or Kaspars be the right person to ask because most of things that are invented in the startup house are innovations, so there is always a question whether to invest in securing something new or it's not worth, because the risk of someone stealing it is hypothetical. So sometimes you do not secure intellectual property, nothing happens to you.
Tomorrow.
Yeah, I mean, from legal perspective, it's quite. I'm quite sure that you have to protect your intellectual property. What I can comment is that from tax perspective, if you have any expenses occurred when you form this intellectual property, then these are considered as business expenses. And in other countries, like for example Luxembourg, you can significantly reduce your corporate income tax by accumulating R&D expenses or any other expenses, or you make it like a amortization of those in your accounting. But this is not working in Latvia because we don't have a profit tax. So if you have this in your company, and if you have a large significant expenses on your intellectual property, then it's better maybe to have company in Luxembourg, Switzerland, but they are very expensive as well. So to have company there, it's you have to plus minus have at least 100,000 euros annually on having the company just sitting there.
Thank you. And would you know whether it's an iterative process? So if you operate in Latvia, then your intellectual property is secured there. First, you secure it here, but then, as in the previous example, you get suddenly customers from another country, and then do you have to invest in securing it in another region again?
Kaspar,
s-
that's legal question. Do you, I think you, yeah, yeah.
So there are three ways how to protect your intellectual property, essentially. First one, and it depends on the type of property. If you are talking about program code, that usually means that it is considered a work under copyright law, similar to a movie, a book, etc. In Latvia, it is considered automatically protected at the moment of creation, the moment of creation being when it is expressed in any material form. If it's in your head, it's not protected. If it's on material form, including as a computer code, it automatically becomes a work and it is protected. And so it is recognized by most countries. There is a World Intellectual Property Organization. There are intellectual property treaties. For example, in USA, you can register your work to assist with that protection, but it's actually not required. So creating code is essentially already protected from copy. Of course, if somebody does something, you will have to sue them, which could be not that easy. Another layer is patents. There are also software patents. Registering patents is good. Investors will like it, but it's hard and quite expensive in Latvia and in other countries. And short answer to your question is that once registered in Latvia, it is not automatically protected throughout the world. You need to register, well, essentially in every country, but there is a process how you can do it more easily, but it will cost you. Third way is just to keep it secret. Famous example, recipe of Coca-Cola is not patented. It's just kept as a secret. Well, everybody knows this recipe. Essentially, the brand value of Coca-Cola is actually the brand, but technically, Coca-Cola protects its recipe by just keeping it a secret. And it is also protected, so you can choose. Investors will like patents, definitely, they will love them. If you have, gives you a huge value. Copyright is also fine. Trade secrets, yes, good, just keep them secret. But one thing about intellectual property, definitely have in your agreement with your employees a clause saying all the code, all the intellectual property that you create under direction of the employer using employer's resources belongs to the employer. If you don't have it, actually it's not that completely automatic that it is your or company's or employer's property. This is what, and most of you probably are working with software, will actually look at. They will ask, please, could you please show me that in agreements with all your employees, you have this clause. So have it.
Yep. Still alive? That's all from my side, actually. Thank you.
Great, thank you very much. Maybe I want to ask, like, we have still time until 1 o'clock, for maybe some private conversations with some of the teams. Would it be okay if we could arrange it in a boardroom, maybe? And is there anyone actually from teams that are on site that would like to have a conversation about like some specific topic regarding your idea? One team, okay. Any other team? Not there yet. Okay. Like then let's start with first team, and if you have additional questions, just feel free to reach out. Okay. Thank you very much.